here at Matthiesen, Wickert Lehrer. I practice primarily subrogation, and this is an area that I deal with on a weekly, if not daily basis. It's something that tends to be problematic or perhaps more mysterious than it may be difficult. So getting into that, this is something I hear a lot, that there is no subrogation for Michigan motor vehicle accidents. You know, that's a very general kind of assessment of a very complex issue, which I imagine if you're in attendance right now, you probably know how complicated, long, and maze-like the No-Fault Act can be, especially when it comes to subrogation. And this is something that I tend to see very often, you know, in files that I'm working on or emails that I get, questions that I have. Everybody says, hey, you know, I've got this health claim. We've paid out benefits. Maybe it's an ERISA plan. Maybe it's work comp. But it's in Michigan, so there's nothing I can do, right? Well, that's not necessarily true. You know, there are a lot of ways to attack these problems. They can be more complicated than it ordinarily seems, but it doesn't always have to be impossible. And as it says right there on your screen, like any other subrogation claim, it depends. You know, if you've got an ordinary subrogation claim, we're talking about health subro here, you know, you might be dealing with in one state, well, you've got comparative fault is going to bar the claim at 50%, or you've got made whole doctrine, or maybe you haven't put somebody on notice. You know, there's always a lot of boxes that need to get checked off to get you through from one side of paying a claim to the other side of getting recovery on it. And hopefully this webinar is going to help you do that in the state of Michigan, where you've got somebody, one of your insureds or plan participants injured in a motor vehicle accident or pretty much anything involving a motor vehicle. You know, so before you end up closing out the claim prematurely, I'm hoping this will help, you know, turn some files that would otherwise be closed into successful recoveries. And I hope that you all find it as interesting as I do. Not everybody does, but you know, this is something that I've really worked very hard on in the past couple years, and I deal with, like I said, very often. And it's actually a heck of a lot more interesting than it sounds going in. So getting started, I'm going to go through the more relevant provisions of the No-Fault Act as sort of a disclaimer getting started. Obviously, the No-Fault Act is relatively long. Not everything in it is going to be relevant to subrogation. And so obviously we can't go through the whole thing, and I just want to say that this is not a comprehensive webinar on the entire No-Fault Act and how it operates. What I'm trying to do in the next couple slides is go through more of the basics. I can't really get into extreme details about, you know, every sort of exception or circumstance and, you know, everything else that tends to come up. But I think that this could definitely be useful. So starting off, you've got, here's the No-Fault Act. You've got your coverage requirements, which is that the auto insurance is mandatory. And then we're going to be focusing on the PIP benefits. Obviously, for health subro, property protection benefits is not going to be incredibly useful. And then we're going to talk about some of the tort liability provisions, which I think is where a lot of the mystery comes from when we're dealing with no fault. There we go. So the required coverage. An owner or registrant of a motor vehicle required to be registered in the state of Michigan must maintain security, i.e. auto insurance, for payment of benefits under personal protection insurance, property protection insurance, and residual liability insurance. We're going to be talking about the personal protection insurance. So the takeaway on that is that it's mandatory, it's compulsory. It depends on if you're the owner or registrant of a vehicle that is required to be registered in Michigan, although that's not necessarily the only limitation on that. And then you've got three kinds of insurance. You know, you've got PIP, property, and residual liability, which would be, notwithstanding the tort exceptions, and bars tort liability is, essentially your basic liability insurance. One little caveat on that you might want to take note of, when you're handling claims down the road, is that out-of-state vehicles, that are not required to be registered in Michigan necessarily, do have to have, essentially a Michigan PIP endorsement if they're operated in the state of Michigan for more than 30 days in any calendar year. So the question is, when are they payable? What gives someone access to PIP? Well, under the PIP insurance, an insurer is liable to pay benefits for accidental bodily injury arising out of the ownership, operation, maintenance, or use of a motor vehicle as a motor vehicle, subject to the provisions of this chapter. Personal protection insurance benefits are due under the chapter without regard to fault, hence no fault. I guess it's probably bad for the PIP carriers, but as you're going to see later on, this is something that can be very useful for subrogated carriers going down the road. Okay, so what's kind of the basic of that? The bodily injury has to be accidental. Obviously, if your guy runs his car into a telephone pole on purpose, that's not going to do you much good. And you're talking about ownership, operation. Operation is kind of the crucial one, operation and use of a motor vehicle as a motor vehicle. What that means is there's some exceptions for parked cars, but, essentially, I think one example would be someone tried to get PIP benefits because someone shot them with a gun out of their car, and they wanted to get PIP benefits because it involved the use of a motor vehicle. And I don't think it was moving at the time either, but the court said, no, we're not doing that. So just keep in mind that it does have to be sort of a typical driving, getting in, getting out, loading, unloading situation. And kind of the good thing about this, too, is that you might have more unique circumstances arise, which, like I said, could be loading, unloading. Maybe someone might be doing something in the bed of their truck, moving some boxes around or something, and they slip on some collected water that's in there, fall out of the truck and hurt themselves. That could conceivably entitle them to PIP benefits, but it's really got to be done on a case-by-case basis. Every circumstance has to be looked at by itself. And so as soon as you get your facts in, you got to do sort of a general analysis, and I can't go through every case, obviously, as far as that's concerned, because we're just doing sort of basics here. But I just want everybody to think outside the box a little bit as far as what might access somebody, to PIP benefits. So I'm going to do a quick hypothetical here that might, there's a couple of them that might illustrate sort of how this works. Casey Cautious is driving through an intersection when Dan Driver runs a red light and slams into her car. She's severely injured as a result of the accident. She can't work for a long time. She's losing wages. Does she get PIP benefits for that? Okay, sure. That's a very typical situation. She's driving a car. She gets hit by another car. A more interesting situation that you wouldn't ordinarily think about as far as subrogation is concerned, you got Tammy Texter irresponsibly loses control of her vehicle on the highway while using her smartphone, flips over a ditch and runs into a tree. She's severely injured, and she's probably never going to work again as a result of the accident. Is she entitled to PIP benefits? Yes, she is, because she's driving the car. It involves use or operation of a motor vehicle, and it doesn't matter if there's another vehicle involved or not, because we're not talking about third-party liability here. We're talking about statutory insurance coverage for medical and wage loss. So, yes. The third one, we've got Dan Driver. He slips on a puddle of oil in a parking lot 5 feet away from his car. Is he entitled to PIP benefits? Probably not. There have been some cases out there to the effect of people getting in and out of their cars and how close are they, is their hand on the door handle and things like that. So you really do need to watch out. I mean, honestly, unless it's, a very simple, like I said, one car accident, or you've got a pretty standard collision, you might want to shoot that over to somebody for an opinion, because there's, it goes into a lot of case law and can be sort of difficult to determine. But it's at least worth looking at, I find, ordinarily, to give it a shot, as long as there's any kind of motor vehicle involved at all. So the question is, what benefits are paid under PIP? The big one is medical expenses. And it's really kind of amazing, because there is no time limit on how long the PIP carrier would have to pay the benefits. It could be for life. It could be 10 years, 15 years. It doesn't really matter. And there's no dollar cap on that either. And that's all statutory, which probably is unfortunate for the auto carriers paying out the PIP benefits. And I think there's some legislation that they're looking at currently in Michigan. But as far as it stands right now, it's completely unlimited. The wage loss, that is capped off at 3 years. And what they do is you sort of prove up your wages, and then they reduce that by 15%. And they do have monthly maximums, which change from year to year. I think it's somewhere in the ballpark of a couple $1,000s right now. But there is a maximum amount. And so that's something to keep an eye out for, which I'll mention later on down the road. And then there's another feature called replacement services, which is, it would be things like if you have to have someone come over and clean the house or buy you groceries, things of that nature. And that's a maximum of $20 per day. You're going to see those claimed a lot, but I think that for the most part, as far as standard health and accident insurance is concerned, that's probably not part of the normal coverage on the subro end, so it might not be all that relevant insofar as trying to recover on that is concerned. So the next big thing, and this is where you end up getting into a lot of fights with folks, which is priority. Who's primarily responsible for paying the PIP benefits when someone gets injured? A lot of times you're going to have people with multiple cars. They've got different policies on different cars. Their spouse has a policy on the same car. When you have commercial vehicles, that gets even more complicated, because you could have a tractor, you could have a trailer, you could have a commercial policy, you could have a personal policy. And 9 times out of 10, there's going to be a fair amount of finger pointing before anybody pays any PIP benefits. Not always. It's common that people are, going to take care of it if the facts are really clear. But if there's any shadow of a doubt, mostly you're going to see a lot of dispute about that. So for the most part, this first part, occupants generally, what they're going to do is they take the claimant, and if they've got a personal policy, that's going to be the primary insurer. If they don't, or if there's some sort of complication with coverage or something like that, then it also would be, it would go to their spouse's insurance coverage, or if there's a resident relative, maybe not in that direction, but supposing your insured doesn't have no-fault insurance, maybe they live with their dad or their brother or something like that, and they do have it, there's a good chance that the dad or brother's carrier is going to be responsible for that. And second one, I haven't really seen a lot of this, but occupants of vehicles in the business of transporting passengers. So you're looking at taxi cabs or things like that. They would go with the insurer of the vehicle as opposed to a particular person. There are some exceptions to that. There are things like buses and sort of more government-related things. I think they try to sort of cover themselves as far as public transportation is concerned. Occupants of employer-owned vehicles, that would go to the insurer of the vehicle, again, the owner or registrant of the furnished vehicle. And that applies to the employee, the spouse, and again, resident relatives. Why they included the employee is kind of odd to me, and I'll discuss that a little bit later, but they did, and that's just sort of how they decided to do it. If none of the above apply, which I think would take some extraordinarily odd facts, then the insurer or owner of the registrant of the vehicle would be first, and if there's no coverage there, then the insurer of the operator of the vehicle would be next. So I'm going to do another quick hypothetical here, which is Casey cautious, she's driving through an intersection, and Dan driver runs a red light and slams into her car. She's insured by Acme Auto. The car is her father's car, and it's insured by Carolina Indemnity. Casey's severely injured and out of work for a long time. Again, poor Casey. Who's first in line for paying her PIP benefits? Well, it's going to be Acme. Her own insurer is going to be first. It doesn't matter about the other person's liability coverage. It doesn't matter which coverage is on the car. If she's a named policy holder with Acme, then Acme is going to be the one on the hook for paying those benefits. Again, Dan driver causes another accident, and this time he's injured. The vehicle belongs to a friend and is listed on a policy insured by Acme. Dan lives with his brother Rick, who's insured by Beta. Who's responsible for paying Dan's PIP benefits? Well, that's going to be Beta because, again, you're not looking to who insures the vehicle, which is, I guess, somewhat uncustomary depending on how you're looking at it. But he is domiciled in the same household as his brother, and his brother is a named insured on the Beta policy. Coordination of benefits, this is really can be a very useful tool for health, accident, disability carriers, and ERISA plans, which is that an insurer providing personal protection benefits may offer at appropriately reduced premium rates, deductibles and exclusions reasonably related to health and accident coverage on the insured. So that would be, basically your other health and accident coverage. Any deductibles and exclusions offered are subject to prior approval, et cetera. That's not necessarily dispositive there, but it applies only to benefits payable to the person named in the policy, the spouse of the insured, and any relative of either domiciled in the same household. So you're looking at other health and accident coverage. I'll mention the work comp issue in a second. Basically this means that they can put a coordination of benefits clause, or usually it comes in exclusions in the policies that I've seen. They can exclude coverage for that. They don't have to pay it, except for certain circumstances, which we'll discuss later. Another thing to note, though, is that it's discretionary. It's not automatic. Probably a lot of PIP carriers are going to tell you otherwise when you submit a claim to them to reimburse for medical benefits you've paid. But it's always important to verify that it actually is a coordinated policy, because I find a lot of the time it's not. And I also would point out that it does only apply to the named insured, the named insured spouse, or again, a resident relative. And that's important to note because you've got to remember that there are a lot of commercial vehicles out there on the road, and I think a lot of occupational accident carriers, it's going to be especially key to look at, because if you've got a policy that's issued to ABC Motor Carrier, Inc., then even if they've got a coordination of benefits clause on there, it's not going to matter, because your driver, if it's Joe Schmo who works for ABC, he's not a named insured, and obviously he can't be a spouse or a resident relative of a corporation. But this is going to be a really crucial factor. This is the big thing that's been especially useful for me. And so just keep an eye out for that. Maybe make a note of it, put a star, highlight it, whatever you got to do to remember it. This is a typical, supposed to have another slide here of a COB provision, but you should have that in your notes. I don't have to read through the whole thing, but it's just to give you an example of what sort of exclusion you'd be looking at. Nope, that'll be the next one. My apologies for that. This is the work comp portion of the coordination issue, which is that benefits provided or required to be provided under the laws of any state or the federal government are subtracted from the PIP benefits. And mainly that's going to come up in workers' compensation. You probably will see that in every policy. It doesn't matter. It's statutory. It's mandatory. It's not even discretionary that anybody can, change that. So if you've got work comp benefits being paid, that's going to be offset automatically. Here's that COB provision I was talking about. This is essentially, it's an exclusion. Pulled this out of a number of the cases, discussing who owes what. But yeah, it's pretty typical. They're talking about blanket group or accident disability, medical or surgical reimbursement. And so that's going to be used against any health accident carrier or probably ERISA plan that says that they want to get paid back for the benefits that they've paid. So this is probably one of the most important. I know I mentioned the coordination of benefits issue, but insofar as that's concerned, this is really something you've got to look out for because this applies to the claimant. And if you're talking about subrogating to their right to PIP benefits, it's completely crucial. You've got to look out for this. Okay, the statute of limitations for filing a claim for PIP benefits is 1 year from the date of loss, unless you give written notice to the no-fault carrier or the no-fault carrier has paid PIP benefits. Usually it's going to be the former rather than the latter, so getting notice out there is extremely important. But as far as the 1 year is concerned, you can file within 1 year after giving notice, but you cannot recover for losses or damages incurred more than 1 year before the date the date suit is filed. This is known as the 1 year back rule. And what's really important about that is, you might have an extension on your statute of limitations. Let's say you've got an accident that happens on January 9th of 2014. Now you've got until January of 2015 to give notice to the carrier, and conceivably you could file suit a year after that. But if you paid hospital bills on the first day that the accident happened, if you go any later than that, every day that passes, whatever benefits were paid before that date, before that 1 year cutoff, you're not going to be able to recover for in a direct action to recover your benefit payments from a PIP carrier. Now, the big thing here, where I think a lot of the confusion comes from as far as not being able to, quote-unquote, subrogate in Michigan for auto accidents, is the abolishment of tort liability. So this is tort liability arising from ownership, maintenance, or use of a motor vehicle within the state of Michigan, with respect to which the security required was in effect, is abolished, which means there is none, except basically intentional torts, damages for certain non-economic losses, which it's another provision. It's not going to be quite so relevant for the standard PIP reimbursement claim. And then you've got basically PIP benefits in excess of the PIP limits. Obviously, medical is not going to fall under that because it's unlimited under PIP, so no matter what you pay in medicals, it's not going to be in excess of PIP. And another issue is PIP coverage for out-of-state residents. I'm not going to be talking about that provision. It's very complicated, but it's got a statutory offset that would probably bar a reimbursement claim regardless. So something to think about here is that only tort liability is abolished. So that means if you can come up with any sort of contract claim or other indemnification, that shouldn't be barred necessarily by the No Fault Act. So it's worth looking into other areas. And it's also got to arise out of the ownership, maintenance, or use of a motor vehicle. And so it doesn't necessarily, it's not necessarily going to apply to, say, premises liability, if that had anything to do with it, products liability. I was just reading a case last week where that's okay, you can pursue that. Depending on the circumstances, that shouldn't be abolished. And it only applies to auto-related injuries within the state of Michigan. So if you've got an out-of-state accident, tort liability is not abolished for that. And as far as the non-economic loss is concerned, a person remains subject to tort liability for non-economic loss caused by his or her ownership, maintenance, or use of a motor vehicle only if the insured person has suffered death, serious impairment of a body function, or permanent serious disfigurement. This is commonly known as threshold injuries, which means it sort of gets you over the hump of being able to bring a third-party claim for, basically pain and suffering. There's a number of sort of caveats that go along with that as far as how that's going to operate. Things like comparative fault's going to apply. If the claimant, the person injured, that's looking for, their non-economic damages, didn't have their no-fault security if it was required, they're not going to be able to get any damages under that either. So there's no geographical limitation like there is on the other subsection of that part of the No-Fault Act. And it refers only to the claimant's ownership, maintenance, or use of a motor vehicle. And, for the most part, unless you're a self-funded ERISA plan, you're not really going to be able to recover under the non-economic losses anyway. So third-party subrogation. This is the one where we get a little complicated. I think this is what most people try to do and sort of run up against a lot of brick walls because of those limitations that we just talked about, those bars to tort claims. And so this is why everybody's saying, no, you can't subrogate for auto accidents in Michigan. And the reason is that your basic subrogation principle, that a subrogee stands in the shoes of the subrogor and acquires no greater rights than those possessed by the subrogor. Take that in conjunction with the fact that the No-Fault Act bars recovery of medical expenses or disability in certain cases from third-party tortfeasors arising out of the ownership, maintenance, or use of a motor vehicle. So what that means is because the subrogee or the subrogor cannot recover, then the subrogated insurer can't recover for that either. If they don't have the claim, how can the subrogee have a claim? It's pretty basic. So insofar as pursuing these claims is concerned, you can either try to make a direct claim, very limited circumstances. So you've got to have a viable claim under 3103. So it'd be something like I said, out-of-state accident, another one of those exceptions. Your losses in excess of PIP. So if you paid, wage loss that was more than the maximum monthly benefit or more than the statute allowed for, or you've paid it for 5 years instead of, instead of the 3 by the statute, then, it might be worth looking into. As far as a lien is concerned, you're not going to have really a valid lien unless, that your insured has a viable third-party claim in their own right. But if they do, or if it's even arguable, you might be able to get your foot in the door and make a reasonable attempt to recover on that. So it's not necessarily everything's, completely lost just because the accident occurred in Michigan or is somehow related to no fault. And at this point, I'm going to announce our trivia question, which we like to do in every webinar here for Matthiesen, Wickert Lehrer, which is you can submit your answer to this question through the webinar or email functions, and the winner is going to get either their choice of an ERISA book or an auto book, which is ERISA Subrogation in all 50 states or auto subrogation in all 50 states. Question is, which late 70s television sitcom star is now a professional poker player? So you can take some time to think about that while you're not focusing hard on no-fault subrogation, and submit your answer to our marketing coordinator, and you might win a book. Okay, so ERISA, this is the more interesting part of third-party subrogation, in my opinion. And if you're an ERISA plan, this is probably a good one to pay attention to because you've got better rights than more or less anybody else here. Okay, preemption, obviously that's the big thing. If you're a self-funded plan, ERISA is going to preempt more or less relevant portions of the No-Fault Act. If you're an insured plan, it's not preempted, and you're basically going to have to go back to the same exceptions and whatnot that I was talking about before we did our trivia question. second part of the ERISA subrogation issue is that recovery from the participant's settlement or judgment, which is usually what we're trying to do here on a third-party ERISA lien, it depends heavily on the plan language here. If you've only got subrogation language, then you can't recover because you're stuck with the same principle that I talked about before, which is that if your participant or beneficiary does not have a viable third-party claim, well, then you're not subrogated to anything useful. There's nothing for you to recover from. They didn't bring that claim, so it's not really going to matter. But if you have reimbursement language, the distinction being, one would say, well, we're subrogated to all of the beneficiary's claims, et cetera, and reimbursement would say more, well, if you recover from a third party, then you've got to pay us back in full. Hopefully you've got you've got language in there to abrogate common fund and made whole and all that stuff. That's usually what I like to see. But if you do have that, if you've got reimbursement rather than subrogation, you actually can recover from a participant's settlement or judgment, and it doesn't matter whether it includes economic damages or not. So even if it's allocated for 100% pain and suffering, you can still get reimbursed from that. So this basically would mean, that doesn't mean that you could, take an action against a tortfeasor. I probably wouldn't attempt it anyways. So you've kind of, it depends on whether or not your participant is going to bring a third-party claim in their own right. Workers' compensation, third-party subrogation. This is one of the more complex areas, I think, of the third-party subrogation, or, Michigan no-fault and subrogation altogether. It's a little crazy. I'm going to hopefully put it in a way that, makes sense at a basic level. It's really complicated, so it's going to be sort of a head-scratcher no matter what facts you've got. But okay, this is part of the their workers' compensation code, and says that where an employer or carrier has paid benefits, the employee must, after deducting costs of recovery, first reimburse carrier out of any third-party recovery, with the balance going to the claimant and a credit to the carrier. Just to be clear, I don't know that there were supposed to be quotes on that. I think I paraphrased, but that's the gist of it. It's a basic work comp subrogation provision. But there's a little bit of conflict because the employee is also entitled to PIP benefits conceivably under the Act, but they're offset statutorily, like we said before, by any workers' compensation benefits. And a lot of the times, the employee is not going to have a third-party claim for economic damages. So how does this play out? We had a situation, it was in Great American Insurance Company versus Queen. The comp carrier was attempting to recover on their comp lien from the insured's third-party case, and possibly PIP benefits, I believe. But at any rate, they said, look, if an employee is injured in a motor vehicle accident, well, they shouldn't be stuck with more subrogation claims than someone who was injured when they weren't doing their occupation. And odd as it is, the court reasoned that the work comp benefits, because of the statutory setup, are essentially a substitute for the no-fault benefits. So the comp carrier is limited to subrogation rights of a no-fault carrier. And I'm going to talk about that in a second, but essentially puts you in the shoes of a no-fault carrier as opposed to, your basic comp lien rights. But, and here's the thing, if the comp benefits are more than what the No-Fault Act would provide for in amount or duration, then the carrier basically gets back for that portion its right to reimbursement under the Workers' Compensation Code. Usually I think this would be, because the medical is unlimited, usually this is going to be something more along the lines of wage loss that's more than the monthly maximums and going beyond the 3-year limit, which I think probably happens fairly often. I've gotten and answered a number of questions in this area. I've done some work on it. It's a little crazy. It's not a highly developed area of the law here, but the real interesting question is, okay, well, now that I've got this sort of chunk of comp lien, let's say it's $5,000 out of $25,000 that you paid. Well, now is that only available for the like-kind benefits, essentially, does it have to match up with economic damages that the insured recovers or the employee, or does it go basically like a regular comp lien and you can recover from anything, including non-economic damages? So the basic law is that, well, once you've got the subrogation right, well, it doesn't matter how the damages are allocated in the third-party case. If it's pain and suffering, it essentially doesn't matter. You can collect from anything. But how does that come together? So the comp benefits exceed the PIP benefits. The carrier has a subrogation right to the extent of those benefits only to a lien on any third-party recovery by the employee, regardless of whether it compensates for the same elements of loss. So once you get over that hump, again, then you can recover from anything. But before that, you're stuck with this sort of PIP subrogation right that I'm going to talk about in a second. And conceivably, you don't necessarily see this a lot, but you might have a subrogation right directly against a third party to recover for those benefits in excess of PIP. I think that's a less common situation, but if you read a couple of the cases together, I certainly think it's a possibility. It's a matter of debate. I had a lengthy conversation with one of the esteemed partners here at Matthiesen, Wickert Lehrer, and somebody who I would definitely put at the top of national authorities of workers' compensation subrogation. And we had plenty of internal debate on that, so I can only imagine if we had defense counsel on the other side, how that would turn out. But me personally, this is how I see it. I think it's correct, but like I said, it's kind of a nuanced area of law. It's not highly developed, so it's certainly open to plenty of argument by everybody. So the PIP reimbursement, let's say if somebody paid PIP benefits, or you're standing in the shoes of your PIP carrier because you paid comp benefits, subtraction from or reimbursement for PIP benefits paid or payable. So basically you've got a subrogation lien or something like a credit. You can do that only if the claimant recovers on a tort claim, a third-party claim, if it's an out-of-state accident, it's brought in Michigan against an uninsured tortfeasor, or you're talking about an intentional tort. So additional details on this, it's got to be like-kind benefits, so it's only to the extent that the recovery is for damages paid or payable by PIP. It's only to the extent of the recovery, you're capped off on that, minus costs and fees. And the good thing is, though, is that once you deduct costs and fees, it's up to the full amount of the PIP benefits paid. So if your full amount of benefits that are paid is less than essentially your common fund amount, then you can get full recovery. Just some basic subrogation principles here. They do have made whole technically in Michigan. I don't see the argument a lot, to be perfectly honest, but it says the carrier's got no subrogation, where the insured's loss exceeds recovery from the insurer and the tortfeasor after deducting attorney's fees and costs. But, again, this case is from 1919, and I don't typically run across debate about this a lot, but just in the technical sense, it is out there. The argument can be made, so I'd be prepared for it, if you're in the circumstances where that could be an issue. I kind of feel like it wouldn't be too, because most of your situations where you're going to be able to subrogate or recover, it's because you're getting either medical benefits or wage loss benefits, and because those economic damages are so cut off from the pain and suffering stuff, I don't think there's necessarily a lot of debate about, well, what's double recovery and what's not. And of course, there's common fund, proportionate share of costs and fees. It's very standard. And we also had the statutory thing on the PIP recovery. So first-party subrogation, though, and this is my personal favorite, and I certainly recommend looking into it if you can find it, any opportunity. So I would probably pay attention because it's a lot more useful in my experience than third-party subrogation. So 3109 allows no-fault carriers to offset or exclude where other health or accident coverage exists, right? That's the coordination of benefits element in the statute, and, this is going to get thrown in your face almost invariably every time you send a notice or a demand to a PIP carrier saying, hey, our coverage is coordinated, or we've got exclusions, we've got offsets, we want our money back. You're going to get a letter back that says, well, no, it's no fault and you're automatically primary. Not true. Like I said, the offset or exclusion is not automatic or mandatory like it is for the work comp, right? They can offer it for a reduced premium and things like that. They can, but the insured doesn't have to elect it. So what that means is that the no-fault carrier is not just, as a matter of right, automatically, without question, excess in every situation. There are going to be plenty of situations where, in fact, their policies are uncoordinated. They don't have the language for a standard health, accident, or ERISA plan, and you're going to find that your policy is, theirs isn't, and you've got probably a pretty good shot at looking at some recovery there. But everything absolutely hinges on the features, the coverage, exclusions of your competing policies. So if both of the policies are coordinated, both the no-fault policy and the health policy both contain coordination of benefits clauses, the health carrier is going to be primary. And the reason for that is, as lined up in Federal Kemper there, this is known as the Federal Kemper rule. It's a very popular one that you're also going to see a lot. The reason is if they're competing and they essentially have equal rights to this stuff, then what happens is that the court says, well, the PIP carrier's offset is statutory, yours is just kind of private contract, so the PIP carrier wins there. If neither policy is coordinated, then the insured actually can double recover. That's okay with the courts. It's apparently okay with the legislature. That's just how they do it. So that's something to keep an eye out for, too. But, and this is the kicker, and this is the most useful thing for probably, I would hope, most if not all of you are listening, unless we've got some defense folks listening in too. But if only the health policy is coordinated, if the no-fault carrier does not have the offset, which they're not going to want to tell you about, and this is why, because it makes the no-fault carrier primary. If you've got good exclusionary coordination language, something clear is always better, that says, hey, we're excess over PIP or any, auto insurance. That's what I like to see. But you can get around it. There are some cases out there that say, well, exclusions are comparable to coordination of benefits clauses. So I've made that argument plenty of times and find that it's ordinarily successful, and I haven't had too much trouble for it. So now I'm going to talk about ERISA on the coordination issue for a little bit, and it's a bit more complicated. Those same rules could apply, but the main thing here is that for self-funded plans with coordination of benefits clauses, that statutory exclusion is basically preempted. So it's not going to be a problem in that sense. If you've got a no-fault insurance policy and a self-funded ERISA plan that both contain coordination of benefits language, then the ERISA plan is given full effect over the state law, over the No-Fault Act, and the no-fault carrier is going to be primary. So it's essentially reversed, because if you look at the previous situation, it's that, okay, well, the PIP carrier is statutory, and the other one is the health carrier is private contract, so the statute wins. Well, this time, when you've got the health carrier who's under ERISA, then you're looking at ERISA trumps the state statute, which is kind of nice. But if the plan's not self-funded, if you got a fully insured plan, then the usual priority rules are going to apply, as I discussed above. In the Glover case, you had a coordination of benefits issue and a reimbursement issue. The plan didn't have coordination language, but it did have reimbursement language. So what happened was the court said, well, the plan beneficiary has got to reimburse the PIP carrier due to, because of the reimbursement language, But then because those benefits were never technically quote-unquote paid, then the PIP carrier becomes primary for that, and they have to pay the insured for the money that the insured has paid to the ERISA plan. In the practical sense, nobody really wants to deal with a long, drawn-out, sort of robbing Peter to pay Paul situation where, PIP carrier says, well, I'm going to pay the insured, and then they'll reimburse you, and then I'll pay you for whatever you reimburse them. Usually, if you can put it out there that say, hey, we're an ERISA plan, this is what we're going to do, I think, most of the time they're just going to pay the ERISA plan directly. And then if there's a dispute about, coverage or offsets or, who's primary, then probably they just file an action for declaratory judgment. Workers' compensation, unfortunately, because those PIP benefits are automatically offset by comp, you're not going to get any reimbursement from the PIP carrier or from the employee. So there's two basic ways that you can do this as far as recovering from the PIP carrier or the insured, depending on how it goes. Either A, you can try and assert a lien on the insured's recovery. You can intervene in the action. You put everybody on notice and sort of do it how you might do any sort of health lien in a third-party case, typically. Or you can do a direct action against the PIP carrier, because technically this is you're equitably subrogated to the insured's statutory and contractual rights to PIP benefits. Pros and cons, the liens, if you're missing deadlines and you don't have all the information, you can't necessarily investigate or identify the carriers, you don't want to incur the cost of litigation, then that's a good thing about it, although the deadlines, I'd still be careful about it because, they still will probably raise that later on down the road. So if you did miss them, I would intervene as soon as possible to protect your rights. But yeah, and the issue here is you're going to be subject to equitable issues, which is, you've got common fund made whole. Some of that stuff might get thrown in your face, and I'd be careful about that. Or the direct action, which for me I prefer because you're not going to have any equitable deductions for attorney's fees or made whole. You might actually even be entitled to costs, fees, and interest, depending on the circumstances. Ordinarily, I don't think you're going to, see yourself recovering for that in a, typical, okay, we'll pay you situation. But you do have to be really careful about getting the notice out there, meeting the deadlines, and you've got to do some investigation, not on the facts because you don't care about negligence, but you've got to find the right carrier, because if you don't file against the right carrier, you're not going to be told tolling of the statute of limitations, that's not going to be, told. They're not going to wait around for you if you file against the wrong carrier. They're just going to say, well, that's too bad, you missed it. The good thing is, and this is my favorite, is that you don't have to establish tort liability. You don't have to mess around with, oh, I got to find witnesses, I got to worry about comparative fault. You can recover on a one-car accident where your own insured was being a complete idiot and, managed to rack up thousands of dollars in medical bills and wage loss in a one-car accident. I think it's pretty great that you have a chance of collecting 100% for that. So you don't need as much investigation as far as getting the facts, witnesses, things like that, but you do have to, definitely look into who the carriers are. And I find that a lot of the times, if you find the right carrier, you get them all the paperwork they need. I don't typically have too much of a problem recovering on that. It's settlement, so maybe not, you're going to get 100%, but I think typically you're going to see more of a recovery on that than you would on a typical sub-rel lien. So just to recap on working the claims, how I would approach automobile/Michigan related subrogation claims, is that, first of all, you want to look at, is no fault implicated? Is there any chance that no fault is implicated? Second, you're going to want to look at who are all the possible no-fault carriers, auto insurers, any sort of insurance who's going to be involved here, even slightest chance. And then I would also take a look at the third-party claims because, you might have something that's going to apply regardless of the sort of limited chances that that's going to be your best recovery option, but it's good at looking too. And then what you want to do is once you've found all your carriers, you've looked at tort liabilities, that you've got to go through and you've got to try and make some sort of determination of who your main target is, who's going to be first in line for paying these PIP benefits. Obviously, you don't want it to be you. So you've got to look at that, find out who's going to be first under the statute, definitely put them on notice, put everybody on notice. And because of the deadlines that we're working off of here, it's very, very important that you act quickly. So just to elaborate on these a little bit more, what are triggers that I look for if I see a Michigan motor vehicle accident or anything, with a car and Michigan? Obviously, any motor vehicle accident that occurs in Michigan, I think you're pretty good to go there. You're going to have definite implication of no fault. I would say, like I said, don't overlook one car crashes. This is a great opportunity to recover where you wouldn't be able to do so under third-party tort liability. Pedestrians, or I should say non-occupants, there might be some different priority rules for that, but people who aren't in the car, not necessarily driving or riding in the car, but as long as they're anywhere in, on, or around a car, a truck, motorcycle, anything, I would definitely look into the no-fault aspect. And the other thing is, too, is that, even with out-of-state losses, if you happen to catch it while you're going through your information that somebody involved is a Michigan resident, then I would also say, okay, well, we might have some no-fault here, especially if it's your own insured and they're a Michigan resident. There's a good chance they're going to have a personal policy. Identifying the possible carriers. Obviously, you want to find out who's your insured's auto carrier because they're going to be first, the spouse's carrier. Resident relatives, who do they live with, their dad, their brother, doesn't matter. Look into it, see if they've got insurance, find out if they've got other cars, garage cars, classic cars, anything registered and, even remotely on the road in Michigan. See if there's policies on that. It's not always easy, but, ask around, see what you can find. Sometimes it can be useful, if you find one carrier, they're oftentimes pretty happy to give you information about other carriers because they want to dump off the coverage on somebody else. But I would also look very closely at commercial vehicles because it's been my experience that a lot of times the commercial policies have less of a tendency to have coordination language than personal policies, but neither is a given in any situation. Evaluating the third-party claims. What's going to authorize you to collect, or bring a tort claim in the state of Michigan? If you got an out-of-state accident, you can do it. If you've paid in excess of PIP, that's something to look at. Uninsured tortfeasors. Be creative. Find some different theories. You have contracts, products liability, anything that you can think of, like a breach of implied warranty or something like that. I mean, I've seen all kinds of crazy stuff, but it's worth looking at. Assessing the priorities. Not always the easiest. You might find some crazy facts once in a while, but I would say definitely, look at your own policy, see if you've got the language. If you don't, I would say it's can't responsibly be pursued, but make sure that you've got it. Find any and all other policies you can. Find out if if you've got an ERISA plan. Look at your language. Look at the facts. Is it funded? Is it insured, self-funded, whatever. And then, kind of try and go through the list and say, okay, well, who's first in line here? Who's definitely before me so that you know who you're going to go after. Now, this is sort of the real big thing is acting quickly, and I think this goes along with the investigation, too, because that can be very time-consuming. But coordination of benefits claims, if you don't know, I would get it out to counsel, get an opinion, find out if you've got a viable claim, who you should talk to, who you can point fingers at, who you can possibly say is going to be primary over you. But if you do have a target that you can say, all right, look, I think this person's supposed to be primary, definitely give them notice as soon as possible because it's got to be within 1 year of the date of loss. Make sure that you include information in there, your insured's name, insured's address, where was the accident, what are the details of the loss, maybe if you've got information about the injuries. Get all your supports together, fill in the facts, Contact any attorneys involved. If, file suit if you need to. I would definitely do it within 1 year because you got the 1-year back rule. Might bar you from, collecting on some fairly substantial medical benefits especially. And if you got to intervene in the insured's action, I would probably do that as well. Third-party claims, I would just try and find the best argument I can for asserting a lien on that if you've got anything colorable. Make a demand on the other parties, responsible party, their carrier, tell the plaintiff or the insured, put all of, any attorney on notice that you're making a lien, and, if you can file suit or intervene, I would do that. So, I might be able to take 1 or 2 questions, but first we got to go through the winner of our trivia question is Brian, and I apologize if I mispronounce this, Brian, but Brian Reuther with Gallagher Bassett is the trivia question winner, and our marketing coordinator, Jamie Breen, will contact you following the webinar to see which book you would like. So let's see if I have a question here. Let's see. What if a person is driving a rental car and does not live in Michigan? What carrier is primary, the driver or the rental car company? Well, without having a lot more information than that, if they don't have any personal insurance for the rental, that's the second part of the question. I guess I would try and contact the rental car's carrier. A lot of times they're self-insured, though, too, which makes it difficult. I'm assuming this accident is in Michigan. So I would probably look to them. I would try and find out the driver if they do have personal insurance. I would look to them first. It's kind of a shoot first, ask questions later sort of thing when you're dealing with no fault. And, you put everybody on notice and kind of get it to see how it shakes out after that. As far as rental cars go, something like that, I was looking into this recently, and the interesting thing is it can be possible to look to these sort of rental agreements because then you're looking at contractual sort of liability that they're taking on, and you might be able to somehow access a third-party claim on that, but probably it's not going to be covered by third-party by the other person's liability insurance because it's going to be liability assumed under a contract. So I think that is all the time we have for today, but I certainly enjoyed speaking with you. Oh, my goodness, I forgot to tell you all the answer to the trivia question, which is Gabe Kaplan of Welcome Back Kotter. He is now a professional poker player and, as I understand it, quite successful at it. But again, thank you for joining us. It's been a pleasure. I hope you all had a great time listening, and I hope you learned something. And I look forward to speaking with you later on. If you got questions, certainly feel free to contact me. And if you submitted a question during the webinar, I will answer it as quickly as I can. Thank you very much.